Thank you. Good morning, guys. We can't waste our time, so we're gonna start with our agenda, which is we need to help our main client, Miss Ida, to settle down all her 5 issues. So without further ado, let's start our first issue. Before we start our first issue, we need to know what is a brief fact of the case. As been mentioned by Miss Ida, she buy a product named Immune Patch from the company named Cepat Sihat Sedia Berhad, which they have made a nationwide advertisement that claim this product can allergize or can repair all the skin allergies, and they promise a 10,000 ringgit to be claimed if the skin is unrepairable by 30 days. After Miss Ida buy the product, unfortunately, the skin is still same. And when she want to claim it, the Cepat Sihat Sedia Berhad reject and refuse to make it. Since they only mention it's only an ITT or invitation to treat and not an illegal offer, even though they have made a 100,000 ringgit deposit to June back as an sincerity. So the issue is whether the advertisement that have been made by Cepat Sihat Sedia Berhad is an legal offer or is count as an invitation to treat. So before we go more deeply, we need to know a concept of offer and invitation to treat. So when we're talking about offer and invitation to treat, offer is be made by the specific person or to the world, and it also be made expressly or impliedly. It also mean it must be clear and it must following the law. Compared to the ITT, ITT is a statement which not intended to binding a law, such as advertisement, display of goods, tenders, auction, and club membership. And based on the issue right now, we can refer to the main section in the Contract Act 1950. The first section we can refer is section 2A, that is clearly mentioned once the other person have agreed by the words or doing the action, a binding contract is confirmed or is be formed. It's also have been repeated in the section 8 of the Contract Act, where it is mentioned that if you take what the other person offer or in return doing the action or doing the same things, it also means you're accepting it. And you need to keep in mind we have a unilateral contracts where usually when we're talking about ITT or we're talking about an offer, unilateral is always be used compared to bilateral, which means unilateral is means to the world rather than one person. For the cases, we always gonna use Carlyle and Catholic Smoke Balls 1892, where in the cases the judgment said it's a unilateral offer when the Carbolic Smoke Ball have deposit 1,000 euro to the banker to show their sincerity or consideration to make a legal binding offer. So, what the conclusion we can take from it? It's literally obvious that Miss Ida can claim that 10,000 ringgit from Cepat Sihat Sedia Berhad since she have made an unilateral offer, which is she accept the offer and fulfill the the performing the condition. Now I would like to pass to Mr. Shafiq for the second issue. Shafiq, where's Shafiq?
Shafiq? Yeah, where is he? Where did he go?
Help. I guess I'm stuck in this laptop. Greetings everyone, I'm Shafiq and I'm here now. So let's continue on the second issue. The second issue is now whether Hafiz and Aida can legally enforce the agreement between their fathers. to each pay the 50,000 ringgit to the couple despite them not being the original parties in the contract. To briefly recap, in the scenario, Rahman and Johan, which are their fathers, that they made agreement to pay each of the couple 50,000 ringgit to them if they had get married. So they had get married and Rahman has paid 50,000 ringgit. But yet Johan died, so he did not make any payment in that sum. They tried to make a claim to Johan's executor to claim for the 50,000 ringgit, but the executor claimed that they were not the original parties, so they could not make such claim. So now let's take a look at the case of Twaddler and Atkinson. So in this case, it was held that the son could not legally enforce the agreement between his father and his father-in-law to pay him money upon his marriage, as he was not a party in the contract. Similarly, in the scenario, the agreement has occurred between Rahman and Johan only for the benefit of Hafiz and Aida, in which Hafiz and Aida, the couple, are substantially strangers in the contract. Now, let's take a look in the Malaysian case. So, in the case of Kepong Prospecting Limited and Schmidt, the contract was made in the benefit of Mr. Schmidt, but he could not enforce the agreement itself because he was not a party to the original contract. Just like the scenario in the case, the agreement between Rahman and Johan was to the benefit of the couple. But just like the case, they cannot sue on the agreement because they are indeed not the parties in the original binding. Furthermore, let's take a look into Section 2D of the Contracts Act. It provided that with consideration, the enforcement could move from the promisee to another person. Yet, it was solidified in the same case, which is Kepong Prospecting Limited and Schmidt, that yes, consideration can be made from a third party, but the legal enforcement cannot be made to the third party, even though it could be argued that the children's action of marriage could be seen as consideration. But as in the case and the provision, the being a third party does not mean you can legally enforce to transfer the enforcement from the original party to the third party. So indeed, even with consideration, they could not make such claim for the 50,000 ringgit to the executor. And now, to conclude, Hafiz and Aida are not liable to claim for the 50,000 ringgit as they are substantially strangers in the contract because they were not any part of the parties from the binding. Though marriage is seen as a consideration, but it does not mean they are the contracting parties. So they could not make any legal enforcement, and only the original parties can make action towards each other. So that's all on the second issue.
Hello everyone, my name is Sharisha and I'm the third presenter in our group presentation for this assignment. My role is to discuss issue 3, which focuses on intention to create legal relations. Specifically, I'll be analyzing whether a family agreement between Ida and her mother can amount to a legally binding contract. In this issue, Ida was experiencing financial difficulties. Her mother offered to help her by promising to provide a monthly allowance of RM 2,000 ringgit if Ida resigned from her nursing job and pursued law studies full-time. Trusting her mother's promise, Ida quit her job and relied entirely on the allowance for her living expenses. However, after 1 year, disagreements arose between them and her mother stopped making the payments. She later claimed that family arrangements are not contracts and therefore are not legally enforceable. The legal issue here is whether this promise created a valid contract and whether there was an intention to create legal relations between Ida and her mom. Intention to create legal relations refers to whether the parties intend their agreement to have legal consequences, meaning the agreement can be enforced in court. Although this element is not expressly stated in the Contracts Act 1950, Malaysian courts apply English common law principles to determine intention. The general rule is that social and domestic agreements, especially those between close family members, are presumed not to be legally binding. This is based on public policy, as courts do not wish to interfere in private family matters. This principle was established in Balfour and Belfort, where a husband's promise to pay maintenance to his wife was held to be a domestic agreement and therefore not a legally binding enforceable. Similarly, in Jones and Padewaton, a mother promised to financially support her daughter while she studied law. The court held that the arrangement was based on family trust and goodwill, and there was no intention to create legal relations. However, this presumption can be rebutted if there is strong evidence that the parties intended to be legally bound. This can be seen in married and married, where a written agreement between separated spouses was held to be legally enforceable because the relationship was no longer based on mutual trust and the agreement was formalized. Applying the law to this case, the promise was made between a mother and a daughter, which clearly places it within a domestic and family relationship. There was no written agreement, no express statement that the arrangement was legally binding, and no indication that either party intended legal consequences at the time the promise was made. The facts are very similar in Jones and Padewaton, where a parent supported a child's legal education and the court held that such an arrangement was not legally enforceable. From Ida's perspective, she relied heavily on her mother's promise. She resigned from her job and changed her position, which caused her financial hardship when the allowance stopped. Ida may argue that it is unfair and unjust for the promise to be withdrawn after she relied on it. However, from the mother's perspective, the promise was made out of love, parental responsibility, and family support. There was no evidence to enter into a legal contract or to be sued by her own daughter. In domestic agreements, reliance alone is insufficient to prove intention to create legal relations. In conclusion, although Ida's mother made a clear promise to provide a monthly allowance, the agreement was a family arrangement and lacked intention to create legal relations. Therefore, no valid contract was formed, and Ida's mother is not legally obligated to continue paying the 2,000 ringgit allowance. As advised, if family members intend their arrangement to be legally binding, they should put the agreement in writing and clearly express their intention to create legal relations, as so to avoid future disputes. That concludes my presentation as the third presenter. Thank you.
Okay, so based on the fact, Ida joined a government scholarship bond requiring 5 years service with the Ministry of Health. She resigned after 2 years to work overseas. The government demand full repayments of the bond. However, she argues that the bond terms are unfair and constitute a penalty. The issue here is whether the government scholarship bond entered by Ada is legally enforceable and whether the government can lawfully require full payment after her early resignation or whether such requirement constitutes an unfair penalty. Okay, so first we can discuss about the validity of the scholarship agreement. Under Section 10, Subsection 1 of the Contract Act, a contract requires lawfully consideration and lawful object. However, scholarship agreements are statutorily protected. Pursuant to Section 4, Subsection C of the Contract Act, no scholarship agreement shall be invalidated on the ground that it lacks consideration. This provision was applied in University of Malaya v. Lee Ming Chong. In that case, the defendant received a university scholarship and later failed to fulfill the bond service. He argued that the agreement was unenforceable due to lack of consideration. The High Court rejected this argument, reasoning that Parliament intended to ensure the scholarship recipients remain bound to their obligation to protect public interest. So, in a government perspective, the government can argue that the IDA voluntarily accepted the scholarship and benefit from public funding. Therefore, the agreement is valid and enforceable by statute. For the ISA perspective, she may argue that the agreement is one-sided and she did not receive fresh consideration after graduation. However, this argument is unlikely to succeed due to the statutory exceptions. Second, we can talk about the reciprocal promise and breach. Under Section 2, subsection E and Section 2, subsection F of the Contract Act, mutual promise constitutes valid considerations. In the case of K. Murugasu v. Nadaraja, the federal court held that an exchange of promise amount to executory consideration, and once a party fails to perform, the other party may enforce the agreement. From a government perspective, the government promised to sponsor IDA's education, while IDA promised to serve the Ministry of Health for 5 years. This reciprocal promise from a binding agreement. By resigning after 2 years, Ida breached her obligation entitling to the government to claim repayment. From Ida's perspective, she may argue that she partially performed the contract by serving for 2 years, and therefore full repayment is disproportionate. However, unless the agreement expressly provides for prorated repayment, partial performance does not automatically discharge the remaining obligations. So third, we can discuss about the allegations of unfairness and penalty. IDA argues that full repayment constitutes an unfair penalty. However, under explanation 2 of the section 26 of the Contract Act, inadequacy or harshness of consideration does not invalidate a contract. In the case of Tan Chiu Tu v. D. Kim Kue, the federal court held that courts do not interfere with the fairness or a bargain freely enter unless there is evidence of lack of free consent. In a government's perspective, the government may argue that repayment clause reflects a legitimate means of ensuring compliance and safeguarding public investment rather than a penalty. From Ida's perspective, she may argue that demanding the entire sum despite 2 years of service is oppressive and does not reflect actual loss suffered by the government. While this may not invalidate the contract, it may be relevant in seeking equitable or administrative relief. In conclusion, the scholarship bond is a valid and enforceable contract, and IDA resignation before completing the bond period constitutes a breach of contract. Legally, the government is entitled to demand repayments. However, from a practical and equitable standpoint, for IDA, I think she may administrative discretion from the government, such as prorated repayment or negotiated settlement, based on her partial performance and length of service. For the government, while legally entitled to full repayment, the government may consider flexible repayment terms or partial waiver to balance enforcement with fairness and public interest. Overall, although IDA's legally challenge is weak, a negotiated solution may be the most appropriate outcome of both parties. Okay, so now I'll pass the last issue to Katika.
Thank you, Sean. Now I'll be discussing on the issue number 5, which is about acceptance in contract law. The purpose of this presentation is to decide whether the legally binding contract was formed between Ida and Laila in relation to the sale of a house. As a general rule, for contract to exist, there must be an offer and a valid acceptance. Acceptance must be clear, final, and unconditional. If the offeree changes the terms of the offer, especially something important like the price, the law may treat the responses as a rejection rather than an acceptance. So, the issue is whether Ida's later message agreeing to buy the house at 500,000 amounted to a valid acceptance after she had earlier proposed a lower price. So, to briefly explain the facts, Laila offered to sell the house for 500,000. Ida responded by offering 450,000 instead. Laila rejected that offer. A few days later, Ida changed her mind and wrote back saying she agreed to buy the house at 500,000. However, Laila refused to sell, saying the offer was no longer valid. So this raises the questions of whether Ida's final response could legally bind Laila. So by applying the law to the facts, under Section 7, subsection A of the Contract Act 1950, acceptance must be absolute and unqualified in simple terms. This means the offeree must accept the offer exactly as it is, without changing any terms. This is also an important case called Heidi versus French in 1840. In this case, the court held that when an offeree makes a counter offer, it is legally reject the original offer. Once that happened, the original offer no longer existed unless the offerer decided to make it again. So in this scenario, when Idea responded to the 500,000 offer by suggesting 450, she did not accept the offer. Instead, she made a counter offer. When Laila rejected it, the original offer was terminated. So when Ida later said she agreed to buy the house at 500,000, there was actually no offer left for her to accept. So considering from both perspectives, from Ida's point of view, she might feel that since she eventually agreed to the original price, a contract should exist. She may also argue that only a short time had passed and that Laila did not suffer any loss. However, from Laila's perspective, the law allows her to rely on certainty. Once her offer was rejected to a counteroffer, she was no longer bound by it. Since she never renewed the offer, she was free to refuse the sale. Legally, the law supports Laila's positions. In conclusion, there was no valid acceptance and therefore no binding contract between Ida and Laila. Ida's counteroffer had the legal effect of rejecting the original offer, and her later attempt to accept it came too late. As a result, Laila is not legally obligated to sell the house. So my advice on this lesson from this case is that parties should be careful during negotiation. If someone wants to keep an offer open, they should avoid making counter offer and instead clearly accept or ask for more time. Thank you.
Okay, thank you guys for help Miss Ida for resolving her 5 issues. And I also want to say thank you to our brief factor, Miss Amalina and Miss Nora, for teaching us and guiding us to help Miss Ida settle all her problems. And last but not least, hopefully we can meet again for our next client. So you guys can give. Thank you so much.